Welcome back to the RG Limited boardroom. Adjust your lighting and pour yourself a glass of something vintage because today we are discussing a legal marathon that makes a century long corporate lease look like a weekend getaway. We are diving into the 12-year Upanga standoff, a saga involving Tahir Muqaddam and the 10-story dream that was nearly buried under a mountain of bureaucratic silence. If you think your projects are moving slowly, wait until you hear how long it takes to fight a temporary suspension in Dar es Salaam. Here is your high society briefing on the Muqaddam and the Ministry trilogy, served with the signature Oksana Rabbit's touch. The scene: the 10-story ghost ship. Back in 2010, Tahir Muqaddam, who is an advocate and clearly knows how to hold a grudge, was ready to build a commercial and residential masterpiece on plot number 1006 1 in Upanga. He had the title, he had the engineering drawings, and he had building permit number 1046. But then the director of urban planning dropped a temporary suspension on the project, citing vague complaints, and the plot was actually meant for a car park. In the RG Limited boardroom, we call this developmental sabotage. Act 1: the 2011 opening move. Tahir didn't just sit in the dirt and pout. In 2011, he marched into the High Court seeking leave to quash that suspension. By 2015, the state's attorney looked at his arguments and basically threw in the towel, saying they wouldn't object. The judge granted Tahir leave to file his main case. A win, right? Wrong. Act 2: the 7-year silence. The court's oopsie. In the boardroom, communication is everything, but in 2015, the court delivered its ruling in the absence of both parties and, get this, forgot to tell them. Tahir spent years making long follow ups while his building permit sat in a legal coma. By the time he finally got his hands on the ruling, his 14-day window to file the next step had long since expired. Most people would have retired to a beach in Zanzibar, but Tahir filed a certificate of urgency in 2022. The judge's ruling in March 2023 was a rare moment of judicial accountability. He stated that the applicant should not be punished for the mistake of the court and granted an extension of time. Act 3: the 2023 final strike. 12 years after the nightmare began, Tahir finally got his substantive hearing in May 2023. He argued that the director had ghosted his project for over a decade without giving him a chance to defend his title or even disclosing who the complainants were. The judge, Honorable Mangela, was not amused. He ruled that the right to be heard is sacrosanct. He found it staggering that a suspension could hold a planning consent hostage for 12 years with zero resolution. The court officially quashed the suspension, effectively telling the ministry to follow due process or get out of the way. My final take, key lessons here. Darlings, if you are building an empire, take these lessons to your next board meeting. Number 1: administrative silence is a weapon. The director tried to use a temporary suspension to kill a project via exhaustion. It took 12 years to prove that suspension doesn't mean permanent cancellation. Number 2: the court is human. Even the High Court loses paperwork. If you don't get a ruling, keep knocking on the chamber door. As the judge said, you shouldn't be punished for a court's administrative blunder. Number 3. Procedural fairness is the ultimate shield. The ministry lost because they forgot the most basic rule of the boardroom: Odi alteram partem. Hear the other side. You cannot strip a man of his building permit based on anonymous complaints without letting him speak. Tahir finally has his permit back, but he lost 12 years of rental income. In the RG Limited boardroom, we don't just want the win, we want the time back. Now, if you'll excuse me, I need to go ensure none of my building permits are being held hostage by a temporary ghost. We build in the sun, not in the shadows.